hearing will come to order. Let the record reflect that this is the time and place set before the Public Utilities Commission of Nevada for a hearing in the matter of the joint application of Nevada Power Company doing business as NV Energy and Sierra Pacific Power Company doing business as NV Energy for approval of annual plans for the Solar Energy Systems Incentive Program, the Wind Energy Systems Demonstration Program, and the Water Power Energy Systems Demonstration Program for program year 2014 through 2015. This matter has been designated as docket number 14-02004. Appearing for the Commission today are myself, Dave Noble, Commissioner and Presiding Officer, Steve Traxler, Policy Advisor, and Haley Williamson, Administrative Attorney. Appearing for Nevada Power Company, doing business as NV Energy, and Sierra Pacific Power Company, doing business as NV Energy.
Good morning, Commissioner. Douglas Brooks, appearing for the companies.
Appearing for the Attorney General's Bureau of Consumer Protection.
Good morning, Commissioner. Michael Saunders.
Appearing for BlackRock Solar.
Good morning, Commissioner. Tim Clausen here on behalf of BlackRock Solar. Also here with me is Marty Benson from BlackRock Solar.
Appearing for Bombard Renewable Energy.
Good morning, Commissioner. Marty Ashcraft, appearing for Bombard Renewable Energy.
Appearing for Nevadans for Clean, Affordable, Reliable Energy.
Good morning. Good morning, Commissioner Robert Jones.
Appearing for Solar City.
Thank you, Commissioner. Kathleen Draculich, and at the table with me this morning is Mr. Dan Chaw.
Appearing for Solar Energy Industries Association.
Thank you, Commissioner. Also Kathleen Draculich, and with us today is Ms. Sarah Birmingham.
And appearing for the Regulatory Operations Staff.
Good morning, Commissioner. Jermaine Groves, Assistant Staff Counsel.
And are there any others present who wish to enter an appearance? Let the record reflect that no one has come forward. The record will reflect that the Commission has in its files affidavits of publication regarding the notice of this hearing for this time and place. Is there anyone present that has any questions on the notice or wishes to examine the affidavits on file? Hearing none, the Commission deems that this matter has been duly and properly noticed for a hearing at this time and place. Are there any preliminary matters that we need to discuss?
Just one, Commissioner, we had talked to other parties. The interveners had a witness order that they had agreed to, and I wondered if I might provide that to you this morning.
All right.
When it's time to call the intervener witnesses, we had agreed that Mr. Wilson, NCARE's witness, would be first. Ms. Benson for BlackRock Solar would be second. Mr. Chaw for Solar City would be third.
Here, hold on a second. And why the order of witnesses? In that way?
Nothing in particular, Commissioner. I would like for Mr. Chaw to go first and Ms. Birmingham to go second, simply because she is supporting his testimony from that standpoint.
I have that in my notes. Okay. But besides Mr. Chaw and Ms. Birmingham, is there any other reason?
No.
Okay. We'll just all right. And Mr. Mendel is date certain today, correct?
Yes, Mr. Mendel has a flight late this evening. I would like to take him after the interview witnesses, if possible. And if not possible,
because it is a date certain, I wanted him to go first.
okay, that's fine too.
All right. Besides Mr. Chaw and Mr. Birmingham, is there any other, and Mr. Mendel, is there any other reason for any order of witnesses? All right. The order is going to be Mr. Hargrove, Mr. Mendel, Ms. Benson, Mr. Wilson, Mr. Chaw, Ms. Birmingham, and then staff witnesses, and then the company's rebuttal witnesses.
Commissioner, can we get the order of staff witnesses?
It's up to them.
Okay. I'm just wondering if we can get the staff to.
Ms. Groves, do you have what is your intended order for your witnesses?
Ms. Oleski first, Mr. Whitman second, and finally Mr. Denise. So Oleski, Whitman, Denise, please.
Okay. Is there anything else we need to discuss before we start? let's go ahead and mark the application as Exhibit 1, and that is excluding the pre-filed direct testimony. Errata number 1 will be Exhibit 2. Errata number 2 will be Exhibit 3. I believe that's all the erratas, Mr. Brooks?
That's correct. 2 was enough this time.
Okay. Mr. Brooks?
When, I'll ask the stupid question, just to get it out of the way early. When you marked it, when you said Exhibit 1 is the application, that includes the annual plan document?
Correct.
Then if there's nothing else, we would call our witness, Mr. John Hargrove, to the stand. And while he's getting ready, I would ask that his, how do we call that, his pre-filed direct testimony in this docket be marked as the next exhibit in order.
I will be marked as Exhibit 4.
Will you state your name for the record, please?
John Hargrove.
Mr. Hargrove, did you cause to be filed in this docket your pre-filed direct testimony that has been marked as Exhibit 4?
I did.
And do you support the annual plan document that is contained in Exhibit 1 to this case?
I do.
With regard to the annual plan document, considering the 2 erratas that were filed, are there any other changes or corrections to the annual plan document?
I have one correction that I'd like to make to the annual plan on page 51. It's under the section solar applicants. It's the second bullet from the bottom of that list.
Good, slow down just a minute, make sure everybody gets there.
Page 51, the section titled solar applicants, second bullet from the bottom of that list.
Okay, continue.
The word true north should say true south.
So, on page 51 of the annual plan?
Page 51, the section titled solar applicants, it's a bulleted list.
Yes.
The second bullet from the bottom, the last word in that bullet should be south and not north.
Very good. Do you have any other corrections or changes to the annual plan document?
No.
Do you have any changes or corrections to your pre-filed direct testimony, Exhibit 4?
No.
If I were to ask you today the questions that appear in Exhibit 4, would your answers be the same?
What is Exhibit 4?
Your direct testimony?
Yes, they would be the same.
No further questions. I tender the witness for cross-examination.
Mr. Hargrove, on page 6 of your testimony, you briefly summarized the incentive levels and the two-step process. Is that correct?
Yes, sir.
What would be the benefit or drawback of having an intermediate step between steps 1 and 2, where you took a third of both the incentives and the megawatts for an intermediate step versus having a two-step as proposed?
The only thing we would be able to give you is the numbers today, but there'd be no significant impact.
What would be the benefits and drawbacks of having an intermediate step, in your opinion?
Maybe just a small loss of simplicity in that we had originally intended to propose a single step for all of the remaining capacity, and then we heard from the people involved that multiple steps would be good, so we took a two-step approach. A three-step approach would not be significantly different, and it would not be difficult to enact or enforce.
All right, thank you.
rebuttal, you have agreed to recommendations made by others. Is it the company's intention to stick with your new agreement in the rebuttal testimony? Or are you sticking with the original proposal and are willing to change?
No, I think we're willing to change as outlined in the rebuttal testimony.
Okay, then my questions for that will be tell us of that. Could you please turn to on Exhibit 4? Please go to question and answer 9 on page 5. And this is, in question and answer 9, you outline how you reached the incentive level, the two-step kind of program, by having the 250 megawatt goal and the remaining budget and remaining capacity and creating an incentive to reach that in those parameters, correct?
I'm sorry, I think I'm in the wrong section. I apologize.
Okay, take your time.
It was in my rebuttal. Direct page 5.
Yes, question and answer 9.
Sorry. Could you restate the question?
Yeah, so question and answer 9, you outline how the company had reached the incentive levels by taking the 250 megawatt goal and the remaining capacity and the remaining budget and balancing those two to make sure that the goal was met at the proper incentive level. So you didn't see the budget.
That's correct.
Okay. And when the company developed this incentive level, was the 250 megawatt goal and the remaining in the budget the only parameters you looked at? Or did you look at other guidelines and other? So those were the two parameters you looked to develop this incentive level?
Yeah, relative to the capacity to be achieved, that's the primary number we work with.
And Mr. Hargrove, I know you're very familiar with AB 428 and the guidelines that were put out there, correct? Would you not concede that the commission in AB 428 established how the incentive was supposed to be created? Guidelines?
The commission did, I think the
I'm sorry, the
legislature.
legislature.
Yeah, the legislature did, yes.
And so can you tell me, by just in your question and answer 9 or in your incentive level, how you accounted for demographics and locations for the incentive level?
We proposed in our plan separate categories and different incentive levels for those categories.
How does that equate location?
We don't differentiate between north and south. We have never differentiated between north and south in terms of setting incentive levels since the beginning of the program.
Okay, even though it was a directive from the legislature to include demographics and location, you didn't account for it?
I don't know that location really matters a lot.
Okay. And how did you account for lower social economic status from nonprofit organizations, commercial industry?
We have a low-income category specifically spelled out in the incentive program, and then we've also brought forward a plan under the low-income pilot program.
And then within each of those categories, did you account for system size as dictated by the legislature?
Well, system size is automatically accounted for in the structure of the incentives.
I understand that there's 25 and over, but did you account for the specific for each category besides what the legislature dictated with the 25 and above?
No.
That's okay. I have no further questions on direct.
Ms. Ashcraft?
No questions, thank you.
Mr. Johnston? Thank you. Good morning, Mr. Hargrove.
Good morning, sir.
Mr. Hargrove, directing your attention to Table 2 on page 10 of the annual plan.
Yes, sir.
And this is really showing the solar incentive levels and capacities, correct?
Correct.
But this is just an estimate as far as capacities, because all capacity would be open to each category, correct?
Correct.
And with respect to the capacity shown here, and I think it's even referenced on page 9 of the annual plan, this Table 2 assumes that
40% of the capacity would go to the public and low-income categories, correct?
Correct.
And 60% of the capacity would go to the residential / small commercial and large commercial / industrial categories?
That's correct. It's the amount of capacity, not the number of applications.
Right.
Yes.
And so, with this assumed split of capacity and your proposed incentive levels, this would achieve the 250 megawatt total capacity goal, correct?
That's the plan, yes.
Okay. But if the public / low income categories ended up using more of the capacity than 40%, then you would fall short of the 250 megawatts.
Not necessarily, because there is some flexibility in the way these numbers work, because people don't always build what they apply for. So you might have some elasticity in those numbers, but the general answer to your question is yes. If we were significantly stilted toward the more expensive incentives, then you would potentially overspend relative to the estimates. But we have several subsequent plans, some number of subsequent plans that we could address that.
Okay. But following up on your yes answer, and the yes portion of your answer, if in fact the public / low income ended up using, for example, 30% of the capacity and 70% of the capacity went to the residential, small commercial, and large commercial industrial categories, then in effect, under your proposed incentives, you would actually get more than 250.
Well, we would be able to. We wouldn't do that without checking with the commission first, because the goal is we would try to get to the 250 megawatt goal. If we got there under the spending limit, we would ask the commission, do you want us to continue beyond the goal? But we would obviously not want to continue past the spending cap.
And again, if you did achieve the capacity shown on table 2, that would result in, even though it's 40% of the capacity, it would be more than half of the dollars would actually go to public / low income, correct?
That's likely correct.
It'd be roughly 57%, 43% split.
I'll trust your math on that.
Mr. Hargrove, in question and answer 13 of your testimony, Exhibit 4, line 23, you make the statement, quote, if one customer category has a low participation rate, comma, adjustments may be proposed in subsequent annual plans. And I know that's just a portion of the sentence, but following up on that, you're not talking here about the market adjustments in the first year of the program, are you?
No, sir.
Could you explain what you have in mind there as far as, well, first of all, what in your opinion would constitute low participation rate by a customer category?
Given that we are proposing to open the program to all, in essence, all comers in whatever percentages that they show up, I'm not sure that I have an upper and lower boundary on that at this point, but I think that we communicate with the commission often, and not the least of which in these annual plans, and I would think that that would be something that we collectively as a group, or clearly the commission could direct if, for example, residential did not have a number that the commission thought was appropriate. I think it would, the annual plan process would be an opportunity for us to address that.
So you didn't have any specific triggers in mind, just the thought that the proposal here would be subject to later adjustment if you saw one category not participating much.
Correct.
Thank you. I have no further questions. Mr. Ackland.
Thank you, Commissioner. Mr. Hargrove, when you started testifying, Commissioner Noble asked you a question about inserting an you recall that?
Yes.
Does that, would that, utility company also has a proposal in your testimony regarding the market response adjustment related to capacity subscriptions, correct?
Yes.
Does inserting an intermediate step, as discussed with Commissioner Noble, at all impact the market response adjustment proposal of the utility company? Does inserting an intermediate step, a third step down, as discussed by Commissioner Noble, does that at all impact the utility company's proposed market adjustment response?
I think the answer to that is yes and no, and I'll explain the no first. I think setting multiple incentive levels, multiple steps, as opposed to the two, setting 3, I don't think would be a problem for us to do in this plan. The market response initiative is not specifically to address the stepping down of incentives. It's to address capacity being applied for and reserved more quickly than what likely the intent of the legislature might have been. The market response adjustment is to give the commission an opportunity to look at extraordinary levels of reservation and activity and have an opportunity to do something about it. It's not an automatic step. Putting 3 steps in place without some sort of market response adjustment, there is the theoretical possibility that we could fully subscribe all 3 steps on the first day. And I don't know that that's what the commission or the legislature would want. And I think that the market response mechanism gives the commission an opportunity at some trigger to weigh in and determine what should be done.
Now, without talking about the substance of your rebuttal testimony, you do have a modified proposal in your rebuttal testimony regarding the market response adjustment.
Yes.
I want to go back to question and answer 13 that Mr. Johnson was talking to you about, if you wouldn't mind. I'm talking now about Exhibit 4, Mr. Hargrove, your testimony, page 8, your direct testimony. Okay. You asked the question here, how do the companies intend to manage the subscription levels to ensure long-term program success? And the first sentence in your response is, the companies believe that the market should drive the program. Do you see that?
Yes.
And as a result of that, the utility company is not recommending capacity allocations per category, correct?
Correct.
Okay. Now, you also take that position in your rebuttal testimony. Does that continue to be the utility company's position in this case?
Yes.
Okay. And principally because you think that the program should react to the applications made by the market for the capacity.
Correct.
Okay. Any other reason?
I think there's another, I refer to it in my rebuttal testimony, I'm not sure if it's the appropriate time to go into it. I think that setting specific categorical limits artificially affects the market.
Okay.
I think one of the intentions of the way that we have interpreted the legislation and the regulation of the program over the years is that trying to have the least perverse effect on the way that the market works is the goal, and I think that's very clearly spelled out in Assembly Bill 428.
Okay. Now, you would agree, would you not, that with regard to each element of this program, there is balancing that's ongoing. So, for example, with your statement, you just said these categories, assigning capacity to categories might artificially impact the market, correct?
Yes.
So there may be other things in the program of the legislation that the commission should, or that the legislature intended for the annual plan or the actual program implementation to also take into consideration, correct?
Yes, to both.
So let's take a look at your testimony, question and answer 12, also Exhibit 4. It's the Q&A right before the one you and I were just referring to.
Mm-hmm.
Now, I want you to take a look, Mr. Hargrove, at question 12, you asked, what effect do the companies feel the new 2-step incentive proposal will have on contractors, customers, and the market, correct?
Yes.
Could just take a moment, and I would like you to read that answer and just familiarize yourself with what you said there in the response. Now, there are two references there. The first is at line 21 on page 7, where you talk about stability and predictability. Do you see that?
On which line?
Starting at line 21, the first line of the response says, the commission has heard from industry stakeholders talk about predictability and stability.
Yes.
Okay? And then at the top of page 8 on line 2, you go to predictability and stability, correct?
Yes.
Okay. And for this reason, this is the basis on which the utility company, or one of the bases on which the utility company is proposing this two-step incentive proposal.
Yes.
So do you have a copy there? And Commissioner, I don't know if you want, I have enough copies for everyone here and in Vegas. I'd like to look at the provisions of AB 428 with Mr. Hargrove. Should I introduce it as an exhibit?
Can we reference them to the actual statutory provisions now, since they are in statute?
I actually looked at that last night. This would be NRS 701B 220 sub 1.
I'd prefer, if possible, we use the statutes, since those are the latest and greatest version of AB 428, if possible.
So, Commissioner, I have copies of AB 428, but I did not bring copies of the statute. I actually went online last night to the legislative website and did not see AB 428 integrated into the statute. I was going to bring it.
All right, let's go ahead and we'll use the AB 428 text there.
Thank you. If I might, Commissioner, Ms. Grubbs, in Southern Nevada, there should be copies of exhibits there with the Solar City SIA label on them. And there are 3 copies of everything there. The first, this is the Assembly Bill number 428, Committee on Commerce and Labor.
We've got it, thank you.
I believe Mr. Hargrove has a copy of AB 428 with him.
Go ahead and mark AB 428, adopted in the 2013 legislative session as Exhibit 5. And just for clarification, Mr. Draculich, with this line of question, just so we know for documenting, are you representing both Solar City and Solar Energy Industries Association for this line of question?
I will be for all lines of questions.
Okay, thank you.
Thank you. Actually, Commissioner, there might be a limitation, but I will note that when I get there.
Thank you.
Thank you. All right, Mr. Hargrove, if you would, we've marked Exhibit 5 as the printout of Assembly Bill 428, and if you would go to page 6 for me.
Okay.
There, Section 7 is NRS 701B 220. Do you see that?
Yes.
Take a moment and read paragraph 1 for me to yourself.
Just one, or do you want to read 1, A, B, and C?
Just one.
Okay.
So in sub 1, what the legislature is directing the commission to do is adopt regulations, I'm reading from it, to the extent practicable, let me rephrase that, requiring the commission to adopt regulations in which they, quote, shall consider whether the regulations ensure, to the extent practicable, the cost-effective use of such incentives and predictability for participants, ratepayers, and utilities. And then it goes on regarding maximizing other criteria. Do you see that?
Yes.
Okay, now, with regard to that reference with respect to predictability, there's no requirement or limitation on which provisions of the annual plan or the solar generations program should be predictable. Would you agree with the statement that it refers to a general predictability?
I think in the context of that sentence, it's predictability for participants, ratepayers, and utilities. So I'm not sure that's general, but that's answered your question.
Okay. But with regard to those elements of the annual plan, it does talk about participants, ratepayers, and utilities, but it doesn't say it should only be predictable with respect to the incentives and not with respect to capacity allocations.
Okay.
So, I want you to assume for a moment that there is 1,000 kW left in the, just for sake of this example, 1,000 kW left to be subscribed. Okay. Now, if a participant, and on its behalf its third-party developer, reviews that, and a participant is either a residential customer or a group of residential customers, the assumption that they would make is that there's a lot of potential in that category of 1,000 kW, correct?
If a residential customer realizes 1,000 kW left, they would think that that's a lot. Is that your question? Yeah. Well, compared to the average residential size, yes.
Okay. And the participant, the customer, the participant, and its third-party developer would make certain assumptions about that in terms of planning, like managing that customer's expectation, ordering equipment, correct?
Yes.
It's possible, is it not, that in a very short intervening period of time, two large commercial installations at 500 kW could come in and get the reservation for that capacity, correct?
Correct.
Okay. That represents, would you agree, a low level of predictability with respect to that 1,000 kW for those residential customers?
I'm not sure I understand that question in the context of what a residential customer might think, but two 500 kW projects would consume the 1,000.
If there were capacity allocations in place per category, those residential customers would be able to look at, or any customer for that matter, any eligible participant would be able to look at that category and know on any given day the capacity that would be allocated to that customer group, correct?
Regardless of the number of categories, yes.
When you were speaking with your counsel, you made a correction to your testimony, excuse me, you made a correction to the annual plan. On page 51, you corrected north versus south for the 70-degree orientation. Does the utility company currently have installations for solar projects that are oriented more than 70 degrees from true south?
Well, the utility company doesn't have installations.
You're right, thank you. Let me rephrase that. Are there currently solar installations that have been put in place as part of the solar generations program that have an orientation that is more than 70 degrees from true south?
Yes, they were for projects that were applied for before 2011.
Okay. And does the utility company currently use PowerClerk to adjust incentives at any rate for those installations that are oriented more than 70 degrees?
No.
And can Power Clerk make that adjustment?
Yeah, I spelled that out in my rebuttal testimony that it can.
Can you explain to me how Power Clerk does that?
Yeah, I'll give you my layman's version of that. Any installation that is oriented beyond a predetermined number, and I can't speak to what the other utilities are, but for the sake of this argument, let's just say it's 70. Anything that is more than 70 degrees north, I suppose east or west of true south, anything that's above 70 degrees is derated. The amount of the incentive that is paid for that project is derated. Generally an upfront incentive, but I think they do it in a performance incentive as well. But it's derated because it's assumed, and actually it's for sure that that installation won't generate as much energy as one that faces within the parameters. So there's some step down in the incentive paid.
Is it only the orientation, or is there also an input for tilt or azimuth, or is it just the orientation?
I can't answer that question. It's a design factor, so you might assume that it does, but I don't know.
Has the utility company run examples using Power Clerk to determine what the incentive drop might be for facilities, let's say, that are 90 degrees true south?
Yes, we have.
Do you have a bandwidth or an estimate of what the adjustment would be as compared to the recommended incentive level?
I don't remember what our numbers were exactly, but I do remember that when I read the numbers that were provided by Mr. Chaw in his testimony, that his numbers were very close to what ours were, so I would go with the numbers he provided.
His number was, from what I recollect, a maximum of 10% reduction in the incentive level.
Well, that was his recommendation.
Yes.
The number was around 10% less that was created by projects beyond the 70 degrees.
If the commission ordered a maximum of 10%, for example, or the commission fixed a percentage, could that percentage be loaded into Power Clerk?
As I said in my rebuttal testimony, that we could do that, yeah, Power Clerk has that component available to it.
Okay, so I'm just trying to distinguish between a set percentage that the commission might order versus what Power Clerk might do on its own. Is there a difference?
Well, Power Clerk doesn't do it on its own. It has to be programmed, and we could program our use of the Power Clerk system with the parameters that were provided by the commission, or as we do now, if it's anything beyond 70, it's just calculated as zero.
Thank you. Mr. Hargrove, I read in the annual plan, I believe it was at page 58. This would be Exhibit 3. It's the last paragraph on page 58 that starts, although.
I think it's Exhibit 4, isn't it?
Actually, I think it's Exhibit 1,
Sorry.
the annual plan.
I knew it wasn't 3.
Page 58, the last paragraph on that page starts, although more than 230 schools have installed solar through the Solar Generations Program, 59 or approximately 25% of these are Title I schools that serve predominantly low-income populations. Do you see that?
Yes.
When Mr. Clausen was asking you questions, he took you to, or asked you about the provisions of, he did not take you to them, he asked you about the provisions of 428. AB 428 that deal with the entities that are intended to be served by the low-income program. Do you recollect that?
Yes.
Okay. And if we look at Exhibit 5, and you go to section 21.3, the first subsection of 21.3 is, describes the low-income program, and it says, a cumulative capacity of at least 1 megawatt at locations throughout its service territory which benefit low-income customers, including without limitation, homeless shelters, low-income housing developments, and schools with significant populations of low-income pupils. Do you see that?
Yes.
Why, with so many low-income schools already participating in the program as set forth in the annual plan, did the utility company target more low-income schools exclusively for the pilot program to the exclusion of homeless shelters, low-income housing developments?
We looked at the type of customer that we felt we had, given our proposal, the structure of our proposal. We looked at the type of customer that we thought we would have the most success with. And that was schools, because schools are, virtually all school districts in the state are already experienced with working with solar installations. They know how these work. They know what types of savings to expect. They've, most of them have installed solar, so they're comfortable with the technology. Schools are a fairly safe and secure environment, generally fenced, generally fairly well patrolled, certainly occupied most of the time. The public need component of a Title I school, I think, fit clearly with the legislation. The schools were an excellent partner, and one that we felt we would have a great deal of success constructing these projects with, and then working in partnership in long term on the ownership and the maintenance and the operation, and then even on the additional benefits that come from it, such as renewable energy education for the students. That was the primary reason we chose schools as our main focus in the first phase.
The statute is very clear regarding inclusion of homeless shelters, low-income housing developments, et cetera, correct?
Yes.
And I understand your reasons for, that you just stated on the record, for targeting the schools. If the commission is persuaded that housing developments, low-income housing developments, and homeless shelters should be part of the pilot program at the outset, the utility company wouldn't have any objection to that, would they?
No, in fact, I think I said in my rebuttal testimony that we would think that continuing on in what the group of interveners has collectively now described as phase 1, a smaller amount of capacity, 1 megawatt, we would propose to continue on with our schools partners who we've already spent a fair amount of time and effort working on these projects with, and then convening a stakeholders group to help us determine the best potential applicants, or at least type of applicants, for the second phase, along with maybe the identification of some actual projects.
But let's go, now you referred to phase 1 in discussions with the interveners. For the record, we have had some conversations among all the parties, correct?
Yes.
And when you say phase 1, you're talking about the utility company's acceptance of the proposal in terms of installed capacity that staff has proposed that the utility company has accepted in their rebuttal testimony.
That's correct.
Okay, that's what the interveners off this record have loosely referred to as phase 1.
Right.
Okay, now, if the commission were persuaded that that AB 428 requires the inclusion of, or should include, homeless shelters and low-income housing, even in phase 1, again, the utility would have no objection to that, correct?
Well, I wouldn't say no objection. We've obviously started working on this, our proposal many months ago, before our plan was committed to paper. And so we've been working with schools to try and find opportunities to build these, and giving the looming deadline of 2017, January of 2017, the utilities would still propose to stick with the schools for the first phase, and then bring the stakeholders group together to address the rest of the customer types addressed in the legislation.
In the course of approaching the schools as you were developing the utility company's proposal to the annual plan, did you also meet with and interview homeless shelters and low-income housing locations?
No.
So has any investigation at all been done by the utility company for low-income housing and homeless shelters?
We have knowledge of those types of projects because we run the program that many of them are already participating in, so we have some knowledge of that. Obviously, the interveners have a certain portion of knowledge that they've shared with us, but we did not do analysis at the beginning of the development of this plan with looking at specific properties now.
Commissioner, if I might have just a moment? Yes. Thank you very much, Commissioner. That's all I have.
All right, Ms. Grubbs?
Yes, briefly, thank you. Mr. Hargrove, does NV Energy continue to plan to competitively bid the construction of the systems under the low-income pilot program?
We are prepared to competitively bid that. We've not done any further work, given that all of the talks that the interveners have had about potentially different approach. So, but we are prepared and we have a schedule in place to competitively bid that.
Thank you, that's all.
Mr. Brooks?
Mr. Hargrove, can you go back to, I think it was hearing Exhibit 5, the copy of AB 428 that Ms. Dracula asked some questions about, and can you go to the section that she and you discussed on page 6?
Yes, sir.
Just so make sure we're looking at the same thing. Section 7, which is amendment to 70B.220, do you have that?
Yes, sir.
Okay, I'm going to read from the first 5 lines of that subsection 1. I'm going to ask you a couple questions. It starts, in adopting regulations for the solar program, the commission shall adopt regulations establishing the incentives for participation in the solar program, comma, you with me so far?
Yes.
So this section talks about what needs to be in the regulations that the commission adopts concerning incentives. Is that a correct do you agree with that characterization of this?
Yes, sir.
Okay, and then, so does this mean that this section is requiring the commission to adopt regulations that governs the incentives for the programs and not other aspects of the program?
I guess that's the way I would read it, yes.
Okay, so then when you get down to the language several lines further down that you and Mr. Akulich talked about regarding predictability, in your opinion, does that predictability, given what we've discussed, does that word predictability refer primarily or exclusively to the incentives as opposed to other aspects of the solar program?
Well, I think given the word shall on, that takes place in italics immediately after the comma, I would say that it means that they should consider that as part of their deliberations, but it's not specific to the regulations.
But the predictability that they're supposed to consider applies to the incentives. That's the impact, is that the impact of subsection 1, the language you and I have discussed?
Yes.
That's all I have for redirect, thank you.
Mr. Saunders?
No recross.
Mr. Clausen?
No recross.
Ms.
Nothing, thank you.
Mr. Johnston?
No questions.
Ms. Dracula?
Thank you, Commissioner. Mr. Hargrove, can you go to Exhibit 5, page 8 for me, please?
Okay.
I want you to read Section 9 there to yourself. This, Commissioner, for the record, would be NRS 704B 240, sub 1 and sub 2.
It's 701B, correct?
Yes, 701B. Just through sub 2, Mr. Hargrove, just sub 1 and sub 2 through B.
Okay.
This deals directly with the establishment of categories, correct? For the Solar Energy Systems Incentive Program.
Yes.
And sub 2 of NRS 701B 240 requires, it says shall, does it not, that the commission, for participation in the solar program with the goal of maximizing to the extent practicable the number of customer categories participating in the solar program based on demographics and location. Do you see that?
Yes.
Okay. What is that? And then sub B says may establish the criteria and capacity for each category, correct?
Yes.
So this AB 428 certainly invites and allows the commission to establish capacity for each category, correct? That's all I have, Commissioner. Thank you.
Ms. Grubbs?
None, thank you.
Mr. Brooks?
Nothing further, thank you.
Ms. Williamson?
Nothing, thank you.
Mr. Traxler? Mr. Hargrove, with regards to the low-income pilot program and the schools that are proposed, how would the utility ensure that those savings stay with the school and are not funneled up to the school district?
As part of the process of this review, the staff submitted a question of that type to each of the schools, and they responded that to varying degrees that they would try to do that. In our work with the school district, we would ask them to tell us what they could do specifically to that. One of the respondents offered up several different ways to, in essence, enhance their renewable portfolio and the information that flowed from that. I don't think that that rises to the level of what the commission staff and others might be looking for. So I think that there was enough support from each of the schools that we've worked with, 4 in the south, 4 school districts in the north, 1 school district in the south. I think there was enough interest from them that they all said they would try to do that. So we would work to spell that out in whatever contractual relationship we had with them to put those installations in place.
A 250 kW system installed at a school, what sort of savings would there be for that school on an annual basis? Roughly. And if that's something you'd like to think about and...
I know roughly what it would be.
All right.
It'd be in the neighborhood of probably $35,000 to $40,000 a year on energy charges, assuming they were able to benefit from all that and not build credits that they couldn't consume.
In your opinion, having a school save and retain $35,000 to $40,000 a year, is that going to be more difficult for that school to do versus installing a smaller system with smaller savings for that particular school?
For the school, I don't think it would matter a lot. There might become a point of diminishing returns where they maybe didn't want to engage in the project if the system was too small. But I think if we were to reduce it by some percentage, I don't think it would change the dynamic much.
What would be the reasons for not participating if the system was too small?
In the conversations that the interveners have had, the ongoing ownership and operation that the utility had proposed was an issue, and as we spelled out in our rebuttal testimony, we're okay with a different model than the utility owning it and putting it into rate base. One of my thoughts on that to accomplish the interveners' goal there was to potentially turn ownership and operation of the installation over to the school, so that, much like the installations that many of them have now, they would be responsible for the ongoing ownership and operation. So there might be some costs. I think generally, since most of them have done projects, they'd be willing to absorb that cost. But the amount of benefit that flows to the school and the amount of operation and maintenance cost might start getting closer together the smaller the system were. So if we put a 5 kW system on the building, it may not benefit them enough. But if it was 200 as opposed to 250 or something like that, I think the benefit would still be there.
Would the benefit still be there if the utility owned and operated the system versus the school?
The energy benefit would certainly be there, yeah. And then if there was no operation and maintenance cost, that would be a potential savings for the school.
All right, thank you. I have no further questions. You may be excused. Thank you. Mr. Brooks?
That concludes our direct case.
Mr. Saunders?
Thank you, Commissioner. At this time, the PCP will call to the witness stand Mr. Jerry Mendel, and may the witness be sworn. Good morning, Mr. Mendel. Can you please state your full name and spell your last name for the record?
Yes, my name is Jerry E. Mendel, M-E-N-D-L.
And may we have Mr. Mendel's pre-filed direct testimony marked next in order?
Be marked as Exhibit 6.
Thank you. Mr. Mendel, do you have a copy of what has been marked as Exhibit number 6 in front of you?
Yes, I do.
And did you prepare a cause to be prepared what has been marked as Exhibit number 6?
Yes, I did.
Do you have any corrections or additions to Exhibit number 6?
I have no corrections relative to the initial proposal, but there are some corrections based on my understanding of the company's new proposal as was submitted in rebuttal for the purpose of the lower income pilot program.
What are those corrections?
Perhaps the easiest way just to be summarize the points. I support NV Energy's decision to not rate base the expenditures made on the lower income pilot. Secondly, I support the lower income pilot being funded through the solar generations program, subject to the $255 million cap and counting toward the 250 megawatt goal. Third, I support the proposal that NV Energy will not own the PV systems installed under the new lower income pilot, and that NV Energy will not be responsible for O&M on the PV equipment. Fourth, I do not support NV Energy's proposal to provide PV for 6 schools, 4 north and 2 in the south, for a total of 1 megawatt in phase 1 of NVE's proposal. That does not get to the breadth of the lower income entities required by the legislature in establishing the lower income pilot. Fifth, I could support the 6 schools proposal in phase 1 if NVE could demonstrate that there are no other lower income entities that would be ready to implement the projects in phase 1 and to bring them online prior to the next annual plan. If that was the case, I would also recommend then that the phase 2 exclude any additional Title I schools in the lower income pilot to ensure that the full spectrum of lower income entities is addressed in the pilot.
With those additions or corrections,
I have a couple additional ones, yeah.
okay, please.
I'm sorry. Sixth, I do not support NVE's proposal to pay for 100% of the PV costs for participants in the lower income pilot. Past reservations have been oversubscribed at less than 100% payment of the costs. Given that the budgets are limited and the unmet goals are substantial, NVE should not overpay to get participation by lower income entities. 7, I do support convening the stakeholder group to iron out the details of the phase 2 lower income pilot. the stakeholder group should begin meetings as soon as possible and should consider first design of the pilot. What is the question or issue that's being piloted? In my view, it should be to figure out how to get as much lower income participation and benefit for the minimum cost possible. Secondly, it should consider the use of third-party providers to reduce costs, and also to consider whether they actually would reduce costs. Third, it should also consider modifications to the messaging to enhance the interest and participation in lower income pilots without having the ratepayers bear the entire cost of the PV systems. It should identify and investigate non-financial barriers to lower income entities participating in the lower income pilot. And finally, I think it should also identify the types of potential participants in the lower income pilot, including those that may be more disposed than others to participate.
And with those additions and or corrections, would your answers under oath remain the same?
Yes.
At this time, Commissioner, we would tender the witness for cross.
Mr. Traxler.
With regard to number 6 that you just mentioned in response to the question, could you give the commission a little bit more explanation with regard to what NV Energy should do to avoid that situation?
Just so we're clear on number 6, that was the not paying the 100% of the participants' costs? Yes. Again, noting that the participation levels were oversubscribed for many of the programs and are still appearing to be fairly heavily subscribed in the relatively short experience with the step 6. It seems to me that paying 100% of the cost is more than was being paid before. I think if we were to establish a lower percentage, perhaps as low as 50%, which is the limit that was identified in the current regs and under AB 428, that would be a place to start. If it was designated to be a special consideration to be higher, allowed to be higher than that, that might be something a commission could consider. But I think the bottom line is that there's not enough funds available to, and given the legislature's concerns about the use of ratepayer funds, to pay 100% of the cost, and as originally proposed, 100% of the O&M over the life of the productive life of the facility. So to summarize, establish a lower percentage level. I would say that 50% might be a reasonable place to start.
Thank you.
Mr. Mendel, you, in your clarifications, you had indicated that you wanted to see at least an examination of including low-income housing and homeless shelters or other beneficiaries of the lower-income solar energy pilot program phase 1, correct?
Yes.
Why is that?
Well, the legislature called for essentially a broad-based consideration of providing the specialized program, the pilot, for a broader base of lower income participants. As I indicated, if there were no participants other than schools that would be able to step forward, conceivably phase 1 could go ahead with only the schools. But it's also my understanding that there were a number of applications that had been received under prior capacity releases that probably would be able to move ahead under a relatively tight time frame. In this particular instance, the company has perhaps identified a preferred set of lower income participants, namely the schools, Title I schools, in part because they had selected them and worked with them in advance in order to put them in that situation. But if others are able to step forward, I think they should to meet the objectives of the legislature.
If those others were able to step forward, it would simply be in phase 2. Would that still not achieve the broad-based participation the legislature envisioned?
If they were only in phase 2, yes, but I don't see any reason that they would have to be excluded in phase 1 if they were already ready to go forward. And if they weren't ready to go forward, then I would say yes in consider them in phase 2, but then really not limit, then exclude further participation from the schools at that point to make sure that it is balanced.
If there was not enough participation in phase 2 from those other entities, would you agree that schools should be allowed to participate in phase 2? The Title 21 schools?
Yes and no. The yes is if it was truly determined that there weren't others available to participate. No, in the sense that at this point it seems that the schools have had a more special relationship with the utilities, as Mr. Hargrove had indicated, in dealing with them, having discussions with them. And as a result, I'm not convinced that if others were afforded that same level of opportunity and working in advance of actually filing the application and so forth to encourage them, that others would not be similarly encouraged.
Looking at the demographics of lower income population in Nevada, what type of participants would represent the largest number of those lower income customers? Whether it's homeless shelters, low income housing, or students and the families that they represent that attend Title 21 schools, if you know.
I don't know, but generally speaking, there might be other entities, including some of the senior centers, seniors facilities, things of that nature that may be predominantly or substantially lower income as well.
All right, thank you. Mr. Traxler.
With regard to the question on how much of the funds, the percentage of the funds that should be covered by MV Energy for the low-income program, you're suggesting something less than 100%. Was that addressed anywhere in your rebuttal testimony?
I didn't have rebuttal testimony. I only had the direct testimony, and I did.
I'm sorry, direct testimony.
Yes, I did address that, at least briefly. On page 6, lines 23 through 27.
Okay, thank you.
Mr. Clausen.
Thank you. Just a few questions to, just stated on the record that you would support the stakeholder group getting together as soon as possible and kind of work on the phase 2 issues. Is that correct?
Yes.
Would BCP support the stakeholder group getting together as ASAP and working with NV Energy to meet your other suggestion that you would not support 1 megawatt to help identify other low-income housing shelters, social centers that could participate in phase 1? Let me put it this way. If the stakeholder group had information that could help NV Energy find other participants in phase 1, Would that be beneficial and help with timing?
Yes, that would be beneficial and help with the timing.
So would you support the stakeholder group assisting with phase one?
I would personally do that if the stakeholder group can be convened that quickly. Yes.
Thank you. No further questions.
Ms. Ashcraft?
No questions, thank you.
Mr. Johnston?
Thank you, Mr. Mendel. Just following up, I think I understand on the 7 points that you made in addition to your direct testimony today. And I believe it was point 4 was that you were not supporting the 6-school phase 1 proposal, correct?
That's correct.
But and then point 5 is that you could support that if the schools were the only entities who could take advantage of this phase 1 capacity, correct?
That's correct.
Now, then point 6 was that you do not support 100% payment of costs, correct?
That's correct.
Now, I guess the question is, would point 6 trump points 4 and 5 in that if no one could go forward immediately without 100% payment of costs, would it be your recommendation that there be no phase 1 and there be a stakeholder group to see how best to proceed?
That's an interesting question that I have not considered in full detail in advance, but it is my opinion that rather than pay 100%, when 100% was more than was necessary earlier to attract participation, that it would be better to defer the implementation of the phase 1, pending, coming up with some lower value with which to proceed.
Thank you. I have no further questions.
Ms. Draculich? Thank you. Mr. Mendel, one of your points on your list was the involvement or participation by third-party developers.
Yes.
Okay, and can you read that point to me again?
Well, it was, in essence, one of the charges to the stakeholder group, as I had identified it, and indicate the stakeholder group should consider the use of third-party developers as a method of reducing costs, and also to ascertain whether the stakeholders, whether the third parties were actually able to reduce costs.
If there is a determination that third-party developers can reduce reduce implementation costs, program costs, would that go toward addressing your concern about the utility company or the ratepayer? I'm sorry. Would that go toward addressing your concern about 100% of the development costs for this program being paid for?
Yes.
Okay. Thank you. Thank you, Commissioner.
Ms. Grubbs.
Yes, thank you. Just briefly, just to clarify, in prior years, prior program years, where schools had installed, didn't the incentive levels at that point cover sometimes more than 50% of the average installed cost?
Yes.
And then if I could turn you to page 9 of your testimony.
Yes.
At the top of the page, you're discussing the portion of AB 428 that provided for the State Office of Energy to identify grants and other sources of money for the low-income pilot program. Do you recall that?
Yes.
And to your knowledge, has the State Office of Energy identified any other sources of funds?
It is my understanding they have not.
Thank you very much.
Mr. Brooks.
Thank you, Commissioner. Good morning, Mr. Mendel. regarding the testimony you gave and then the discussion you had with Mr. Akulich about the potential use or the evaluation of the use of third-party providers for the pilot program. Let's start with a scenario. Let's assume that the proposal of the company as modified in its rebuttal testimony is approved by the commission, and the company moved forward with a phase one involving schools in which 100% of the installation costs of the panel were paid for by the company, and the school district owns the panels. Under that scenario, which entity benefits from the solar panels on the grounds of the school? Who benefits from that? In dollars and cents perspective.
In dollars and cents, as I'm understanding your question, the school district would benefit through reduced costs of electric power.
Let's change the scenario to one in which the company contracts with a third party to install, own, maintain, and operate the solar panels on the school. And this third party then sells the power from the solar panels to the school at a reduced rate. And let's say significant reduction from the utilities tariff rates. Under that scenario, can you tell us who benefits in dollars and cents terms from that installation?
Again, with that scenario, the school district would benefit from a reduced cost of electricity. The school district would benefit from not having to maintain the systems, presumably conduct the annual O&M over the productive life of the facility, of the PV facility. And the third-party operator would presumably benefit with some kind of profit margin on their investment.
Is one difference between the two scenarios you and I have just been discussing that in the first scenario I gave you, the school district is in essence getting the electricity generated by the panels for free, while in the second one, the school district is getting electricity generated by the panels for a rate substantially less than what's in the utility tariffs?
Yes, that would be that half of the equation. The other half of the equation is that the level of incentive may be paid for by ratepayers would also be presumably less for the third-party operator to be a viable option.
Okay. Thank you very much. No further questions.
Mr. Saunders.
No redirect.
Ms. Williamson.
None, thank you.
Mr. Traxler. I have no questions. Thank you. You may be excused. Let's go ahead and take a 10-minute break.